Hello, welcome to the first of 3 videos on bankruptcy. As usual, your class notes can be found on Brightspace. So I'm going to go over the slides with you. If you have questions, you will be able to ask them while we're in class. So chapter 6 is bankruptcy. So to follow, you're going to need the notes first. Second, you will need your Bankruptcy and Insolvency Act. So the blue book that you had to buy. I can't use mine, but I'm going to use a digital version of the same act just to help you out and show you where to highlight. You will also see that throughout these presentations, I'm going to use 2 videos. I'm going to put the links are already in your notes, but I'm going to put them also in your announcements on Brightspace. Okay, so let's talk about bankruptcy. First of all, bankruptcy, you know that it's a federal matter. Okay, so the Bankruptcy and Insolvency Act looks more like the criminal code rather than the civil code. Okay, so just to give you a way, an idea of how it's laid out. So let's start with a little bit of vocabulary, because sometimes people will confuse insolvency and bankruptcy. It doesn't mean because you're insolvent that you are officially bankrupt. But if you are bankrupt, it's because you are insolvent. So let's look at those 2 definitions. What is insolvency? Okay, well, it is defined as the inability for a debtor to pay off debt as it becomes due. Okay, so you have your credit card bills every month, you have your electricity bill, you have all sorts of payments. A person that is insolvent is a person that can no longer make those monthly payments or payments when they become due. Okay, so one step further, after being insolvent, a person may be bankrupt. So bankruptcy, let me give you the definition. Go. So, right here, the bankruptcy is the legal process governed by the Bankruptcy and Insolvency Act for a person who can no longer pay back debt. The person who owes the debt assigns all assets. Of course, there's some exceptions that we'll talk about a bit later, to a trustee who sells it or uses it to pay back the creditors. Okay. So we'll see, not absolutely everything is vested to the trustee, but as you will see, the majority, and the process is that the trustee should take whatever property the bankrupt has, sells it, collect the money, and pay back the creditors in a certain order. So I already told you that the Bankruptcy and Insolvency Act, as you will see in the notes, I will write BIA, okay, is federal. So it means that the process is exactly the same, okay? There's some other process that you will talk about more in detail in Civil Procedure 2, such as the Civil Procedure 1, I think, the voluntary deposit. Okay, but we will talk about some of the provisions from the CCP. Okay. So let's look at the actors in bankruptcy. So there's people that you probably will have never heard about and that you may never will. Okay, but in the Bankruptcy and Insolvency Act, it talks about the superintendent of bankruptcy. So it is the office of the Superintendent of Bankruptcy of Canada. So the superintendent is defined as the government official who supervises the administration of estates in a bankruptcy. If you're wondering who is that person, her name is Elizabeth Lang. And well, that's her. Okay. The definition of the superintendent is at section 5. Section 5 gives you the role of the superintendent. So if I go, let me just get my act. For me, it's at page 11. So I just need to here. So see, the governing council shall appoint a superintendent of bankruptcy to hold office, blah, blah, blah. And it explains a little bit who is the superintendent. All right. Another official, well, you have several. So there is one superintendent in Canada, but you have official receivers. So an official receiver is a local government official. Oops, there's a typo here, responsible. So sorry about that. For receiving documents filed in consumer proposals and bankruptcy. Okay. We will talk a little bit more about the official receiver once we look into the consumer proposal. The third one, that is the one that we will talk the most, is the trustee. So what is a trustee? You might have heard about trustee offices. There's some publicity, sometimes in newspapers or over the radio. A trustee is a person that is licensed by the Office of the Superintendent of Bankruptcy to administer bankruptcies and proposals. The role of the trustee is to represent both the bankrupt, so the person who filed the bankruptcy, and the creditor. Okay. So he is the link between the two. So that's why we say that the trustee stands in the shoes of the debtor, because the property of the bankrupt is vested to the trustee. The trustee will liquidate the assets, collect the money, and pay back the creditors the same way as the debtor would have done outside of bankruptcy. Okay. Just to know, in French, trustee is a syndic de faillite. Okay, so if you've ever heard of that, a trustee is a syndic. So the role of a trustee is defined. So at section 71, we will talk about it on several occasions throughout the presentations. Section 71 of your BIA will define the role. Okay. So it says here on either order of bankruptcy, which is a forced, we'll see the difference in a few minutes, or an assignment, which is a voluntary bankruptcy. Okay. So the bankrupt's property is vested immediately to the trustee. So let's look, oops, sorry about that. So let's look at section 71, page 129 for me. Okay. So see here. Okay. It says at 71, on a bankruptcy order being made or assignment being filed by with an official receiver, we'll see the difference between the bankruptcy and the assignment. Okay. A bankrupt ceases to have any capacity to dispose of their property and immediately pass it and vest in the trustee named in the bankruptcy order or assignment. So that tells you that the trustee will now have the property, will hold it, sell it, and pay the creditors. So there are two types of bankruptcies. Okay. We will start with the first one. Oops, sorry about that. In the first form of bankruptcy, we'll talk about the involuntary or forced bankruptcy. It means the same thing. Okay. This is when your creditors are forcing you, okay, to file bankruptcy. So it is not the bankrupt or the insolvent person that decides to go and file bankruptcy. This is forced upon the debtor. Okay? It is a process that is really not as common as the second one that we will see. So we will look at it, okay, but we won't spend too much time on it because involuntary bankruptcy is not as common as the assignment, which is the voluntary one. Okay, so if you are a creditor and you want to force your debtor to file bankruptcy, what do you do, or what are the conditions? Well, you're going to need two conditions. The first one is according to section 43. Okay, here, condition number one, the debtor must owe to the creditor or a combination of creditors at least the amount of $1,000. Okay, so yeah, no, there's no typo. It's not 10,000, it's 1,000. If you're panicking saying, "Ooh, I owe more than $1,000 on my credit card, so what if?" Don't worry about that. Okay, there's several reasons why you wouldn't qualify. The first one will be, well, you need the second condition. Okay. So on top of owing at least $1,000 to your creditors or a creditor, because it can be one or more, you also have to have committed an act of bankruptcy. The act of bankruptcy, we will see them in a few minutes at section 42. Okay, so let's start with section 43. Okay, so page 47. So section 43, and you will notice that in the margin in red, I have put references to other sections of the BIA, and I strongly suggest you do the same. So when you see here next to 43, when you see 49, put it. Okay, because you'll see 49 is the section that talks about assignment, so the voluntary bankruptcy. And 42 is the list of active bankruptcy. Okay, so the two conditions, the first one, okay, subject to this application, one or more creditors may file in court an application of bankruptcy where it says that the debt or debts, if you have several with different creditors, amounts to $1,000. Okay, so first thing, you have to have your debt of $1,000. And condition number two, and these are cumulative, okay, you have to have committed an act of bankruptcy within 6 months preceding the filing of the application. Okay, so the act of bankruptcy are at section 42. That's why you see here 42 in the margin, and you can do the same on your paper copy. What are the acts of bankruptcy? Well, look, it can get very technical. So I'm going to present them to you in a general way. And you'll see some of them are easier to understand than others. Okay, so let's not overcomplicate things for now. Let's just look at general categories. Okay, what are an act of bankruptcy? Well, the first one, you've committed an act of bankruptcy if you've decided to file a voluntary bankruptcy. Okay, it says assignment of his property to a trustee. So if you've been to a trustee and you've done an assignment, you've committed an act of bankruptcy, which is kind of rhetorical because, well, you're already bankrupt. So there's no point for a creditor to file an application and request the forced bankruptcy of a debtor because the person already assigned the property. But anyway, here, okay, if in Canada or elsewhere a debtor makes a fraudulent gift, okay, so you're maybe wondering, well, what's that? Well, you'll see B and C, okay, are similar. Okay, so to make a fraudulent gift, if I decide, I don't know, I'm gonna give you, let's say I own a Ferrari and I decide to give it to you or sell it to you for $1,000 when it's actually worth $297,000. Okay, so you see, it is a gift that I'm giving to you, and it's based on the fact that the only thing I wanted to be removed from my patrimony. Okay. C, if you transfer the debtor's property, okay, well, create a charge on it that would, under the Act, be void in Quebec, null as fraudulent preference. Okay, so if I try a little bit the same way as B, so if I try to give away my property, at one point it was very common before the different matrimonial regime, but all of the sudden husbands would gift the house or transfer the house under their wife's name. The wife hadn't worked a day ever in her life, and all of a sudden they would transfer the house under her name, the car. You get the idea. So here, if the goal is to remove, I have that, and I want to remove elements from my patrimony, this is a fraudulent, okay, preference or a fraudulent gift. Yeah. D. See this one, D. If with the intent to defeat or delay his creditors, he departs out of Canada. Okay. If a person leaves with the intent of not paying their debt, I'm not saying that they went to Cuba for a week. Okay, get the point, they're going to come back. But if they decide to leave, okay, travel the world for 2 years, and you know very well that the reason why they're basically fleeing Canada, okay, to avoid to pay, okay, that would be a reason for a creditor to request or file the application in court for a forced bankruptcy. Okay. F, I'm going to reserve for later. Okay, so you can skip it. Okay. G here. G, a little bit like B and C. Okay, because in the application, the creditor is allowed to, and usually that's what they do. When they do the application, they will cite all possible sections, okay, to try to defraud a fraudulent gift, or to, so B, C, G often will all come together. Okay, so if they try to assign, to remove, to secrets, or disposes of or attempt to all of the property with the intent to defraud, defeat, or delay his creditors. Okay, so you're emptying your patrimony. That's what you're doing. H. If he gives notice, that one I like. Let's say if a person decides to give a notice, so they call their creditors, or even worse, they would send them a letter saying, I have no intention of paying you, or I will stop paying you. No, nobody does that. Okay, but in the law, it says that if you notify your creditors that you have the intent to suspend, or that you've suspended your payment, it is an act of bankruptcy. If a person defaults of any proposal, we'll talk about proposal later. So just for now, skip it. And J, if he ceases to meet his liabilities generally as they become due. This is the most common one. Okay, people just stop making payment. They don't necessarily give a notice, like at H, but the person stops paying. Okay, and that is the one that usually will be invoked in the application. Okay, so you get, don't worry, the idea is really not to make you an expert, but just to point out that there are things that a person can do. Okay, if a person leaves Canada with the intent of not paying, if a person decides to give away his property with the intent of not paying, or to actually reduce his patrimony to as low as possible. Okay, and if a person just stops paying, these are like 3 general categories of act of bankruptcy. Okay, so having said that, in this case, the creditor who intends to file the application must go to a trustee. Okay. 2 definitions that will be important. You have the definition in section 2. Section 2 is it's a few pages where it gives you a bunch of definitions, and those definitions are important. What is a creditor? Because you will have different types of creditors. And what is a debtor? So if we go see creditor and debtor, yeah, it's true. So yeah, I just have to go after. That's what's annoying a little bit. Here, the definition. Okay, so I'm just gonna go back. Section 2 talks about definitions. So there's a few that we will look at. We'll come back to claim provable, but if we go down, you have a creditor. A creditor means a person having a claim provable as a claim, because of course, if you want to be a creditor, you have to be able to prove that the person owes you the money. I know it sounds like obvious, but under the law, if I can't prove that you owe me money, then I can't be qualified as a creditor. Okay. And during alphabetical order, here the debtor. The debtor includes an insolvent person, okay, and any person who at the time of the act of bankruptcy was committed by, well, resided or carried on business in Canada. Okay. So that will have an impact a little bit later in the process. Okay. So a question that you probably don't have the answer to, but it's an interesting question because it's something that is important. Who cannot, and I'd like to emphasize, who cannot be forced to go bankrupt under Section 43. Okay, so Section 43 is the forced bankruptcy. Okay, so there are a category of people that cannot be forced to go bankrupt. Okay. If you look, sorry, I'm just trying to, here we go. So a person whose principal occupation and means of livelihood is fishing, farming, or tillage of the soil. So a person whose principal occupation and means of livelihood is fishing, farming, or tillage of the soil. So if you are a a fisherman, okay, or a farmer. Okay. It's seasonal work. Remember, this is principal occupation, not if you are the owner of a fishing corporation and you are incorporated, or your farm is actually incorporated. That becomes something else, because it says a person whose principal occupation and meaning of livelihood. So if you are a fisherman, if you are a farmer and you work, okay, by yourself, okay, in a farm, well, it's seasonal. Okay, so even if you own equipment, like it's a fisherman and he works out of his own boat, well, the boat, the fisherman cannot be forced. So a creditor could not force the fisherman to file bankruptcy. Okay, so why those categories? Well, because they're at risk and because they're seasonal in Canada. Okay, so that's why. So 48, I'm just going to show you the paragraph 2 because it's, well, it's not linked, but it's in the same section. So a person who works for wages, salary, or commission that does not exceed $2,000 a year, $2,500 a year. So your creditors can't force you if technically you're not making any money. Okay, so if you don't work for wages or salary or commission for more than $2,500 a year, okay, then they can't force you. So let's go to section 48. So it says here at 48, sections 43 to 46, that is the forced bankruptcy, does not apply to individual whose principal occupation is fishing, farming, tillage of the soil, or to any individual, okay, works for a salary, blah, 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 that does not exceed $2,500 a year, sorry. Okay. So those category of people can't be forced to go bankrupt. I can already hear your questions. Hold on. Yeah, I know there's a question. Well, and I will most definitely answer it a little bit later. Okay. We'll just finish the forced bankruptcy before. Okay, so if a creditor wants to file bankruptcy, okay, how will they go about it? What is the procedure to do that? Okay, so what are the steps? The steps at 43, and you will see that they are not, unlike in the civil code or the code of civil procedure where it says, okay, paragraph 1, 2, 3, 4, 5, and these are actually the steps. Unfortunately for the BIA, it doesn't work like that. So we're going to go within section 43, but back and forth a little bit. Okay. So the first thing, so you see here, so we will go to 43, paragraph 1, then 43, paragraph 9, 43, paragraph 3, yeah, 43, paragraph 5, and then even the last one is in the regulation. Where is the regulation? It's for you, it's in your book, the same, the BIA, so it's the Bankruptcy and Insolvency Act. You have the law, then you should have a glossary, I think, that you have right after. And then you're going to have the regulation. Okay. And that will be section 70. Okay. So at 43, paragraph 1. Let's go to, oops. All right, 43, paragraph 1. Sorry, I forgot to write my page number. Okay. So this is the one that we talked about. One or more creditors may file in court an application. So the first step is to file, to file your application. That is the one, file the application. Court having jurisdiction. No, prepare an application. Okay. Sorry, I forgot to put them back in the correct order. Okay. So paragraph 1, we'll prepare the application. Paragraph 9, we'll talk about the trustee, I think, if I remember. Yes, paragraph 9. On a bankruptcy order being made, the court shall appoint a licensed trustee. Okay, so the step 2 is the trustee. Because you must mention that the trustee then the next one, okay, is the, I believe is the affidavit at paragraph 3. Oops, sorry, paragraph 3. The application shall be verified by affidavit. Where is it? Okay. Oh, I already have in jurisdiction. Affidavit is this one. Then I'm gonna need to serve my to file, sorry, my application in court. Paragraph 5, sorry. The application shall be filed in the court having jurisdiction, the judicial district of the locality of the debtor. Will file the application. And then there's a tiny little thing about the regulation for the delay. Okay, that is 70. Okay, so 70, paragraph 3. We will go in the regulation. Close this. So now I am in the regulation. I'll give you a second, but you can pause the recording while you're looking for your right page. But section 70 is not in the BIA, it's in the BIR, the Bankruptcy and Insolvency Regulation. Okay. So 70 says a notice must be served on the debtor, on the trustee in the application, and on the division office at least 10 days before the hearing. Okay. So we have to file at least 10 days before the hearing. Plus, if you look at paragraph 3, this type of application is served through personal service. Okay, so That is important. Otherwise, they will have a problem with servicing the procedure. Okay? So it must be a personal service. Okay. So 43, paragraph 1, paragraph 9, paragraph 3, paragraph 5, and then 73 and 1 of your BIR. Okay. So a person is forced to file bankruptcy, so they receive the application, it's filed in court. Then what's next? Well, for the debtor, they may contest. Okay. So the contestation, it says here, so the debtor wishes to contest, may serve copy at least 2 days before the hearing, section 74 of the BIR, so the regulation. Okay, so where does it say that they must serve it at least 2 days before the hearing? 74 of your regulation. 74 is here. A debtor who contests a bankruptcy application shall file within the court, blah, 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 and shall serve a copy of the notice, the applicant, blah, 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 at least 2 days before the hearing. Okay. So why? What are the grounds that the debtor may use in court to try to contest? Well, there are several, but let's look at 3 of them. The debt is contested. In other words, you can't force me to file bankruptcy because it hasn't been established that I actually owe you the money. Okay, so if, let's say, we're already in court, okay, regarding that debt, and the creditor decides that he wants to force me to go bankrupt to get paid, well, there's no court who will allow the application for bankruptcy based on the fact that, well, that debt is contested, so you need to wait until the actual procedure, okay, in court is solved before. And then if I owe the money, then that's another process. But if we contest, and if I can prove that it's been contested, the application will be dismissed. Another one, I can try to prove that as the debtor, I did not commit an act of bankruptcy. Why? Well, because an act of bankruptcy is conditional to obtain the application. So even if I owe like $12,000, but if I can refute the part that is referring to the act of bankruptcy, well, then the application will be also dismissed. Okay, so the idea is try to prove that I did not commit an act of bankruptcy. The other one will not delay as much as the first 2, but the service is not done in accordance with the rules of procedure. For instance, if it's not by personal service, let's say I have a creditor and he wants to file an application and he serves it while I'm in class, I'm teaching you, and he serves it at the reception at school. Well, the service is not valid because it's not through personal service. So in this case, what would happen is just that the creditor will send the bailiff again and say, well, serve it again. Okay. So here it says, if the court is not satisfied with the proof or with the service, the application is dismissed. That's what I was telling you just before. Okay. So That's the role of course, the debtor is to try to prove that either the debt is contested or that you haven't committed an act of bankruptcy or that the service was not valid. Of course, as I said, the service, well, they'll just turn around and serve again. So, okay. So whether the debtor decides to contest or not, what's next then? Well, at one point, there will be a hearing and there will be a judgment. Okay, the judge has to make a decision. But before that, it is possible, there is a procedure that is allowed under the BIA, okay, called the interim receiver. I wrote you in your notes that often it is the trustee that may be appointed. So what is the goal for that? Okay. The idea to appoint is that if you're scared for any reason that the debtor, by the time that they receive between the application and the actual judgment, what if the trustee, disposes of the property? Often it is done in the case of corporations. So if you have a corporations and you're afraid that they'll say, well, it's going through the wall anyway, so I might as well make matters worse. Okay, so the little liquidity that we had, how about we all take a trip? Or that, we use catering services and we spend thousands of dollars on expensive wine bottle. How are you going to recoup that? You can't. So if the creditor is afraid that this might happen, they can request before the hearing to have, before the judgment, sorry, at any point, they may request the appointment of the interim receiver. Okay, so we'll go at 46, paragraph 1 of the BIA. So often, as I said, will be to operate the debtor's business. Okay, so if you're afraid at any point, then the interim receiver, which is often, the trustee, the trustee will take the place and will, manage or keep it afloat until the judgment has been pronounced. So at section 46 of the BIA, so we're back into the Bankruptcy and Insolvency Act. Sorry, I forgot to see. Okay, for me, it was page 50. So in the BIA, there was it was a page before. So the interim receiver is section 46. The court may, if it is shown to be necessary for the protection of the estate of a debtor, at any time after filing an application for bankruptcy, order a licensed trustee as interim receiver of the property. Okay. So we use that when we're afraid that for any reason, the estate or the asset of the debtor may disappear. Okay. So that is a procedure. It's not, it doesn't happen in every bankruptcy, but it's a protection measure that the creditor can use. Okay. There is a judgment at one point on the application that will be rendered. If the court authorizes the application, so if they grant it, automatically the debtor becomes bankrupt. The property is vested to the trustee. So see, we're back to square one where we were before. Okay. If the application is dismissed, then hooray for the debtor, and he can continue with business as usual. So that completes the section regarding the forced bankruptcy. Okay, as I said, it is not the most common. Okay, there's the majority of all bankruptcies is the number 2. So what's number 2? Okay. Oops, here, this one. Okay, so now let's talk about voluntary bankruptcy, or what we refer to in the act. It will refer to the assignment. I even told you that it's the easiest and the most common one. Why is it the easiest? It's because you go see a trustee and basically the trustee takes care of everything. Okay. What is the scenario for a voluntary assignment? In the assignment, you set up your debtor, and the debtor wants to get rid of the debts. Okay. So basically that's what happens. So what do? Well, you decide, okay, well, look, what I'm going to do, I'm going to go and meet up with a trustee and see what are the solutions. You'll see bankruptcy is not the only solution. We'll talk about 2 in the second part or the second presentation. So the trustee sits down, asks you a bunch of questions, and decides at one point, yes, well, based on what you're telling me, assignment would be the best option. So if at section 43 that we saw, it was the forced bankruptcy. Section 49 is the assignment. Okay, so an insolvent person with leave of court may assign all his property to the general benefit of his creditors. That's what an assignment is. Okay, so if we go to section 49, sorry. So section 49 of your BIA, 49, where am I at? Here, 49. So assignment. You will notice that in the margin, I've put 43. 43, if we remember, it was the forced one. And next to 43, you have in the margin 49. That means you have to start either with section 43 or section 49, because these are the 2 options in bankruptcy. It's either forced or it's an assignment. So here it says an insolvent person with leave of the court may assign all his property for the general benefit of the creditor. Okay. Sorry. The good thing about this is that, as I said, it's the trustee who will, after asking for several pieces of information from the debtor, sorry, will then file all the documents. Okay. So it alleviates a lot of the stress from the debtor. And this is a question that I could hear you ask through, for some of you through the screen. Okay. Okay, but what about the fisherman and the farmer that we talked before? Okay. So despite the fact that they cannot be forced to go bankrupt, there's nothing that prevents them for filing an assignment. So a fisherman cannot be forced to go bankrupt, but a fisherman can decide to file an assignment. So I don't know if you see the difference between the 2. Okay. I can't force a fisherman under 43, but a fisherman under 49 could decide to go bankrupt. And that is super, 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 super important to see the difference between the two. Okay. So we're the debtor. We went to the trustee. What happens next? The trustee say, okay, yes, we'll do an assignment. Well, you have a few steps that needs to be done. Okay. Sorry. Right here. So the assignment is accompanied by a sworn statement indicating the debtor's property and the creditor's info. So that's the first thing. So one of the things that the trustee will ask of the debtor is, can you give me a list of all your property and the name and info of all your creditors? That's the paragraph 49, paragraph 2. We'll look at it in a second. Okay. Then there is a prescribed form that the trustee must follow, and he has to send it to the official receiver. But before that, it's just a list and there's no assignment. Okay, so you have to have the list, and it must be submitted to the official receiver. That is the paragraph 3. And then I know it looks backwards, but once the official receiver has received, and that's pretty much a job of the official receiver, is to receive the documents. So then the official receiver will officially appoint the trustee, because for each bankruptcy file that is registered with the superintendent, there has to be an the name of a trustee attached to each file. So the official receiver appoints the trustee. Okay, and that's the paragraph 4. So let's go to 49, paragraph 2. It says here, so the assignment is accompanied by a sworn statement showing the debtor's property and the creditor's info, so the amount that is owed to each creditor. So that's the first thing that must accompany the assignment. Then all of that must be filed with the official receiver. Okay. So the assignment under subsection 1 shall be offered to the official receiver. Okay. And it is inoperative until filed with that official receiver, who may refuse if it's not done in the prescribed form. But don't worry, the trustee knows how to do it. Okay. So once the official receiver files the assignment, he appoints the trustee. So then officially, after that, the person is bankrupt and the trustee is on record. Okay, so if any creditor has any question regarding a particular file, they don't call the debtor, they call the official, they call the trustee, sorry. Okay, so again, it alleviates more stress from the debtor's shoulders. Okay, and then it will be the liquidation of the asset that will continue. Okay, so that completes the first part of the 3 presentations. So next time we will look at ways to avoid bankruptcy, and we'll start talking about liquidation of the assets. Okay, so, well, for now, I bid you farewell, and I will see you soon in presentation 2.